I'm here with Aaron Edgar, who is an estate planning lawyer. Aaron, before the break, we were talking about wills and executors. Let's switch gears and talk about updating wills because we know it's important to do that, especially when there's a major life change. Sometimes it's not realistic to do it, every time maybe someone has a child necessarily. But when is it an absolute must?
I think it's an absolute must. Maybe, having children is one thing, and you have to look at the will and see what the will says. So I'm usually encouraging my clients to pull the will out, look at it every, at least at the minimum every 3 to 5 years to make sure the appointment still makes sense, right? And the beneficiary still makes sense. Those are the biggest pieces for people. And you hit different life stages as well. A lot of people, having kids, they need maybe trust to protect the children. They need to have trustees in place when the kids are getting older. Maybe they're able to step in some of those roles like executor. That's a life event for them that, they don't need a third party trustee. They can have the kids acting as the executor and trustee under the estate when they reach a age of majority or maturity.
Yeah, that's actually an interesting point. When does it make sense to have a trust for children?
I think whenever they're minors, and we usually talk about this with clients, is when are kids mature nowadays, and that's the big question, right? When you have toddlers, when is my child actually going to be mature that they can manage money, be responsible? So a lot of time, maybe clients are putting trust in place, maybe until age 25, maybe till age 30, when the children they think may be mature enough to be able to handle the money at that stage. So usually the trusts are fully discretionary, right? The money is there for the child's benefit, but they're only getting the outright everything and full access to the funds at that certain age.
Yeah. So we know one time that it is important is when there is a change in marital status. Either, it dissolves or they get remarried. Walk
Mhm.
us through some of the common mistakes that you see.
Yeah, I mean, I just think, when you're having those change in relationship marital status, it is a big event and you do need to get your wills updated. Normally, you're dealing with your family law lawyer to set out, what the rights are when you separate, but you also want to make sure those things are clear under your estate plan as well. So if you're separating, your will probably still names your spouse, and maybe that's not the plan you want. Maybe you want to skip over, make sure things are just there for the children. Blended families are another situation, right? Where you're maybe remarrying. Maybe you want to make sure the estate is there for your children from the previous marriage, and you're maybe not as concerned about everything going to the spouse when you're both, financially independent at a later stage in life, right?
There's a belief that once you have a will in place, it is going to be done just that way. Now, I know I've personally seen some situations where it is contested.
Mhm.
What do people have to be aware of?
So there's a lot of different claims people can make under a state. So, the big ones that challenge wills are, undue influence. Was the person under influence on some other person to change the will? Were they being forced to do it? And, was the will executed validly? Did the person have capacity, right? So sometimes there's concerns about whether the person had mental capacity when they made the will. So those are some of the bigger ones to challenge wills. But there's also claims that spouses or common law spouses can make against the states, like under the Family Law Act. They can either take under the will or take as if they had divorced on the date of death. So that's one claim against an estate, and usually, your family law lawyer is navigating that with you as well. And common law spouses as well, they can make a claim for dependent support if they were being supported by the spouse and the will didn't provide for them. So those are some of the most, I think, common claims you see when wills are contested.
Let's talk about power of attorneys, which is actually separate from wills, but also
Mhm.
something that a lot of people don't do. What's one or two things that people have to think about when getting it done?
Yeah, I mean, usually when people get wills done, they get powers of attorney done as well. And I tell clients, power of attorney is the most important document you're going to need because, and people think, hey, I'm not going to need, I'm not going to lose capacity. But the truth of the matter is, there's a really high chance that you will not have capacity, at least for a period of time before you pass away, right? And in that time, you need to make sure that your dependents are cared for, right? Can your bills be paid? Can your family be cared for if you don't have capacity to deal with your bank account, your investments, things like that? So it's a very, very important document to have for that reason.
Yeah, and or you can be in an accident or get
Exactly.
sick. Yeah. So is there something that they need to think about, or who should actually have that power of attorney? Typically, the spouse.
Typically the spouse, yeah, in the nuclear family, but it's a similar decision to executor, right? They have to be financially savvy, right? They have to be someone who you trust and manage your assets, but normally it is the spouse first, and then usually you want to have a backup as well, just in case something happens to both of you, right?